Yeah, so she was being evicted by the owner of the trailer. That's not on point with this case. That's not on point with this case, and it's disingenuous for you to imply to the court that it is.
I disagree, Your Honor.
How do you disagree? It's a different owner of the trailer. Owners have different rights than the park owner of a lot.
Your Honor.
The person that owned the trailer Brown was living in had Brown evicted, and as part of that eviction, she lost personal property. That's the same as an eviction on an apartment or a single-family residence. There's a complete body of statutory law dealing with evictions of mobile homes that's not there.
If it's a termination of tenancy case, Your Honor, they would have had 90 days to sell the home. This was not a termination.
But my point is you're presenting Brown as if it's analogous to our situation here, and it's not. It's a completely different fact situation. Well, guess what? I'm wearing the black robe and I say it's not. So Brown is not in my decision-making today. So if you've got something that's analogous to this fact situation where you were evicting a trailer off the lot that you own, but you had no ownership interest in the trailer, then I'd love to see that case law.
The Turner case, Your Honor, once again, is a claim that there was wrongful movement storage of personal property.
Let's start with who did the eviction and who owned the trailer. Go on.
Once again, there was a claim that there was a wrongful removal of property that was taken to a storage facility. The court held that the removal was proper.
But who owned the trailer?
It was foreclosed upon by Bank of America.
Okay, so Bank of America was the owner.
It wasn't foreclosed, I agree.
Yeah, but they owned it. At the time of the eviction, Bank of America owned title to the trailer, correct?
Yeah.
Who was evicted?
The purchaser.
By Bank of America, the owner. So once again, totally different fact situation than Clay versus Park Estates.
Finally, in Barnaby versus PCI, it also is an order of eviction. And the claim was that
Don't tell me the claim. Who was the plaintiff in the eviction?
was the landlord.
The owner of the unit.
I don't believe so, but let me.
Well, if they were the landlord, if they weren't the owner of the unit, how were they the landlord?
Because they leased the unit.
So they were acting on the auspices of the owner. I lease it from Clay. Clay rents it to Landman. That means Clay is the owner for eviction purposes.
I don't, I understand what the court is saying. I don't believe that it is separate and distinct because of the fact that you have an order of eviction.
My eviction authorizes the court officer to get a trailer off your lot, not to go in and dump all the property to the dump. Never in my tenure on the court have I said to the court officer, go ahead, take personal property out of a trailer that the plaintiff does not own and throw it away. That's not what my eviction orders are meant to do.
The eviction order, and in this case, in the case that I provided, and in all three of these Court of Appeals cases, instructs the court officer.
Counsel, you're not catching what I'm laying down here.
I know exactly.
Your client did not own the trailer that the eviction took place at. So all those case laws, the evicting party owned the trailer. You're talking apples and pork chops. We're not even all in the same fruit basket here. So I hope you do. I hope you appeal it. So let's talk about your other reason for the directed verdict. What statutory or court rule authority do you have that I can't take testimony alone on value?
Take testimony, Your Honor. It's got to be supported.
Where's that at? I'm asking you for the court rule.
Claim the raise is 3.1. I think it's 3215. Let me make sure.
Take your time. Sure, counsel, take your time. Mr. Clay is going to go get a drink. No, he wants a break to get a drink. Go. Just don't talk while he's out of the room.
Your Honor, the court rule is 3.105. 3105C2
Hold on a minute. Okay, I didn't know he was back yet. All right, go ahead.
requires the value be stated.
I'm sorry, counsel, 3.105, what? Right,
3.5C2 requires that a complaint state the value of the property, which is not an admission of value. So therefore, in order to establish value, the proofs have to stand. You have estimate from Mr. Clay. You don't have any supporting documentation whatsoever.
okay, anything else?
Indian foundation for value.
Once again, I can't tell you how to present your case, but you don't have to have original receipts to establish value.
So,
I said original receipts for purchase is not the only way you can establish value of an item to the court. Anything else? Okay. All right, counsel, grant your motion. Let's move on to the counterclaim.
Your Honor, as I looked at the counterclaim, the judgment was against Mark Clay. So I do not believe that George Clay has stepped into Mark Clay's shoes. So with that in mind, if Mark Clay decides to file a lawsuit, we will go ahead and pursue a counterclaim against Mark Clay.
I think that means you're dismissing your counterclaim. You're right. I'm sorry? Any objection to the trailer being sold?
If the trailer is titled in George Clay's name,
Who's got the title? All right. So I'm just hearing that that's the only worry they,
well, $16,000 they say that rent. And that's why they have.
okay, well, he just admitted you don't owe any rent. He just said he's letting his counterclaim go because you're not the responsible party for back rent.
See that? Okay.
That's what I just heard.
I'm not letting it.
Okay. All right.
gonna be future litigation. But I suppose if that occurs, then we'll have the issue of whether there are claims that should have been blamed here. Because in a meeting, you say a claim.
I don't like to talk about how many angels can dance on the head of the pin. So if it comes up, we'll deal with it then. All right. Questions?
Well, that tell Parker State that I can only rent and I can sell my friend.
There's rent for the lot.
Which has nothing to do with the trailer. Would you agree?
Doesn't have anything to do with the purchase price. Home's been sitting on the lot for now several years.
Because you wouldn't let him sell it. Your client told him they couldn't sell it. So now you're telling me they can refuse to let him sell it and then say he can't sell it now because the lot has too much back rent on it? Then we're going to be back here for another claim of delivery because you've forcefully taken the trailer.
Well, I don't believe you're being to file our own claim of delivery. That has to be.
No, my point is you can't, on the one hand, you can't say, sure, go sell your trailer. And on the other hand, say, but you can't sell it now because there's too much money owed on the rent and somebody's got to pay us that. You can't stop him from selling the trailer and then hold him responsible for the lost time. So the man needs some direction. Are you authorized to tell him, put it up for sale and get it out of there?
The authorization to try the case based on claim delivery of the spot.
What about your family?
He just dismissed that.
Hold it back, right?
Yeah, but he just dismissed it.
Okay, but.
And I can't stop him from dismissing his case. Right. So I think what I'm hearing from him is you got to sue Park Estates because they've taken your trailer.
Okay.
Have they deprived you of its use and value?
Yes.
That's a taking.
And they last year, they made the mobile homes.
You got to go see a lawyer, Mr. Clay. You got to go see a lawyer. Because a lawyer would have walked out of here with a judgment against them today for claim of delivery. And I know it's throwing good money after bad, but good luck. Have a nice day. Yeah, I think, Carly, we got to e-file that judgment, don't we?
Yes, Judge.
Yeah. Thank you, Mr. Lehman.
As this hearing comes to a close, we've seen a dispute that centered on property rights, eviction law, and whether the legal authorities cited by the defense actually match the facts of this case. Defense counsel argued that prior appellate decisions supported their position, claiming those cases justified a directed verdict and challenged the evidence presented on property value. The judge carefully examined each citation, repeatedly pointing out that the cases involved fundamentally different ownership and eviction circumstances. In the court's view, those precedents simply did not apply because the party conducting the eviction in those cases owned the trailers, while the facts here were materially different. The judge also explained that testimony alone can, in some situations, be sufficient evidence of value and ultimately granted the motion before moving on to the counterclaim, which was effectively dismissed. As the hearing concluded, the judge expressed concern that the trailer owner may have separate legal remedies against the park and even encouraged him to consult an attorney regarding a possible claim. This hearing is a strong reminder that successful legal arguments depend not only on finding case law, but on presenting precedent that truly matches the facts before the court. When the factual circumstances differ, even persuasive authorities may carry little weight. What do you think? Did the judge correctly distinguish the prior cases, or should the defense's legal arguments have been given more consideration? Let us know your thoughts in the comments. If you found this courtroom showdown interesting, don't forget to hit that like button, subscribe for more real courtroom breakdowns, and share this video with someone who enjoys legal drama. Thanks for watching, and we'll see you in the next one.